Hi everyone, my name is Michelle. In the face of such a distinguished panel, if I were you, and if I see my face up there, I'll be wondering who is this person. Like Kian Ming and Chin Huat alluded to just now, I'm actually assisting with filing a judicial review in respect of Kuala Kubu Baru, where basically even without going through the parliamentary process, we saw that the EC actually redrew the boundaries of Kuala Kubu Baru in what they call a Section 7 exercise. Now, since they said that I would talk a little bit about it, it's not part of my presentation, but I would. From time to time, what the EC can actually do is called a Section 7 exercise. Section 7 allows the EC to redistribute polling districts. Okay, polling districts, so you know the district that you're actually voting in. Instead of confining themselves to the power under Section 7 to only amend polling districts, what we saw instead is the redrawing of boundaries of Kuala Kubu Baru, and then on top of that, a shifting of voters from Batang Kali into Kuala Kubu Baru. Now, if I were you, and if I'm reading Section 7 as it is, where Section 7 says I only can amend polling districts, if I go further and to redraw boundaries and to move voters, I would think that that's beyond the EC's powers, and that's why we're bringing the judicial review. Just to assure you that I am not some quack lawyer, I actually went to school. I graduated from the London School of Economics, and I was called to the English bar. Then I came back to Malaysia to serve as a lawyer, I suppose. Okay. How do I work this? Sorry. Oh, okay. Right, so what I'm going to do is I'm going to give you a little bit of background information, followed by the process of redelineation. Then I'm going into the considerations that the EC must take into account when they redelinate. Chin Huat has actually touched a lot on it, but what I'm going to try to do is to focus a little bit on the legal side of things. Right. When was the last delineation exercise? In Peninsula and Sabah, the last one was in 2003, which was 13 years ago. In Sarawak, it was 2005. And now we're in 2016, and it's going on for Peninsula. Right. Before I prepared for this presentation, I asked around and tried to find out legally what the people want to know. One of the questions posed was, does EC do this every single time before elections? The answer is no, because according to the Constitution, there is a minimum of 8 years that must pass before the EC can conduct the next redelineation exercise. Long and short of it is, if nothing is done now, we're going to be stuck with everything that Chin Huat and Kian Ming has explained for the next 8 years, which is not what we want, okay? Right, the process of redelineation is in Article 13 of the Federal Constitution. If anyone picks up Article 13, you would see that it's actually very, very short. It's only, just now I looked at it, 3 to 4 pages. So it's not very difficult to understand. What basically happens is it starts with a notice. It's called a Section 4 notice. What then happens, which is now what we're undergoing now, is a 1-month process where you have to make representations. After this 1-month process, EC will have to conduct a local inquiry, and I'll explain later what to expect at this local inquiry. After conducting the local inquiry, the EC is entitled to revise their recommendations. Okay? After they revise it, it doesn't stop there. The whole process has to go through again. All right? What this means is that you have 2 opportunities to make your representations. We don't want to wait until the second round. If you can do it now, why not? Right, just now I said that I would talk a little bit about what to expect at the local inquiry. At the local inquiry, the EC basically has what, as lawyers, we call quasi-judicial functions. They act as a mini court, in other words. Their powers are actually very wide, and I'm just going to read to you a little bit of what they can do. Number 1, they are entitled to gather evidence, orally or written evidence. Number 2, they can require that any witness make evidence on oath. So angkat sumpah lah, or they can ask you to sign the statutory declarations, which it would have some effect, because if you lie on oath, then there's some legal effects to it, which if you want to know later on, you can come and speak to me. Number 3, they can issue summons to get you to come and answer their questions. All right? Number 4, they can even issue a warrant of arrest to compel you to come if you do not respond to their summons. All right? Number 5, they can fine a person if he refuses to give evidence. And number 6, which is what I don't really agree with, they can exclude the public or the press from inquiry. Okay? I tell you this not to scare you, but to tell you about what to expect after you sign your objection forms, because it's not just simply objecting, you actually have to prepare yourself to be able to answer questions. All right? This is where the quality of your objections come into play. No. It's good that you know now. Right. Okay, let me touch a little bit on the recommendations after the first stage of recommendations. Don't worry, later I'll tell you how to make sure that your objections are good. Okay, what grounds you have to know in your head. Okay, when you ask questions by the EC. All right, so that you can come to some coherent answers lah. Okay, court cases. The court cases that can potentially be filed is what lawyers call judicial reviews. All right? What is required in a judicial review is a decision by a public body. That is why your objections are important, because ultimately, when the EC revises their recommendation, it can be construed as a decision. Whether that decision is right or wrong, we will look at your objections and the process that it went through before the EC came to their revised recommendation. Okay, so it has to be placed side by side. So if we don't have very good objections, the EC can come to not very good decisions, and our judicial review will be a little bit more difficult, but we can still try lah. Okay? So the judicial review can potentially come in at 2 stages, because this Article 13 process is done twice. Okay. Right, so just now Chin Hua said that after the whole process, a report will be submitted to the Prime Minister, and then the draft order will be tabled in Parliament. This draft order, once it's tabled, 2 things can happen. Number 1, it's passed by a simple majority, then, it's gone. If it's not passed by a simple majority, the order will be amended, then it goes through the same process again. If it's passed, then we're stuck with it. Okay, right. Now, I'm going to teach you what the EC must have in mind, or when you go into your local inquiries, what you should be thinking about. Under Article 13 of the Federal Constitution, there are 4 considerations when it comes to redelineation. Number 1, constituencies ought to be, number 1 and 2 are quite soft, but I'll just go through it anyway. Constituencies ought to be delimited so it does not cross state boundaries. And state boundaries don't cross federal boundaries. I'll explain more about it later. Number 2, they have to consider the administrative facilities for registration of polling. Number 3, the number of electors ought to be approximately equal, which is what Kian Ming and Chin Hua touched on just now. And number 4, local ties. Now, this is going to be a bit legalistic, but let me try to explain it in very simple form. Article 1132 of the Federal Constitution says this when it comes to redelineation. The Election Commission shall, from time to time as necessary, recommend such changes that they may think necessary in order to comply with the provisions contained in the 13th schedule. My colleagues have construed it quite strictly, and the effect of this this provision in fact means this. The EC does not have to redelineate or go through the process of redelineation if all these 4 boxes are checked. It is only where, so for example, Malaysia has developed and the population has redistributed, so on and so forth, such that the conditions of the time have moved away from these 4 considerations, that the EC can intervene to ensure that they bring the country back to these 4 considerations and to comply with these 4 considerations. So that is only when redelineation is needed. But in fact, as we have heard just now, not only are we no longer complying with these 4 considerations, the situation is in fact worse. Okay, right, I'll start with what I would call softer considerations here, and then move on to the heavier considerations. Okay, consider administrative facilities for registration or polling. I think that's quite simple. If you look at the notice that is published, what the EC must be able to tell you is whether they have provided for administrative facilities for registration or polling, which means that they must tell you, that there is a school here, you can go here to cast your vote, which is actually quite soft. Crossing boundaries. Now, crossing boundaries, there are 2 prohibitions of what the EC cannot do, right? Number 1, the boundaries cannot cross state boundaries. Constitutional boundaries cannot cross state boundaries, which means, if you look at this red circle here, between Pahang and Kelantan, a constituency cannot be between Pahang and Kelantan, which is quite simple, okay? The second type of crossing boundaries that is not allowed is that state constituencies should not cross federal constituencies, right? As we all know, a state is divided into federal constituencies and state constituencies. What this means is basically where there are federal constituencies side by side, your state constituencies, the boundaries cannot cross the other federal constituency. All right, simple enough. Okay, local ties. I think Chin Hua did a very good job on it. And basically, the questions that you might want to ask yourself is, is my constituency within the same city or district? So I actually have a friend who, now his constituency has been changed to Kinrara in Puchong, but he has been asked to vote in Kelana Jaya in Subang. So, these are the things that you have to think about. Local authority, there was the example of Kota Raja, where one of these constituencies actually spanned across 4 municipalities. Klang, Shah Alam, Subang Jaya, sorry, I can't remember what, sorry, three municipalities. So, local ties is diluted when the people making the decisions in my area, there's actually 3 of them, who am I accountable to? How do I deal with my day-to-day problems? Things like that. One thing that actually caught my eye when this redelineation was announced was the news about the name change. Now, actually, I think that this is a softer issue, but arguably, does it amount to local ties? Yes, possibly. So, for example, name change from Seputeh to Sri Petaling, as we all know, Teresa Cox area, PJU, Tony Swan to Damansara, Serdang to Bangi, Kelana Jaya to Subang. I wouldn't encourage you to object based on name change, but to illustrate what local ties actually mean, it may include it. Ultimately, the difficulty when it comes to local ties is that it can be a little bit perceptive. So, I have another friend who lives in Bukit Jalil. Bukit Jalil somehow last time used to be voting in Bandar Tun Razak, which is very, very far away. So, to her, she feels, actually so far away, what do I have to do with that area? Why am I still voting there? But there may be other considerations that will override it, which is why local ties is actually a bit difficult to argue, but if you want to go into the inquiry with these grounds, it's still possible. Right. Number of electors ought to be approximately equal. The idea behind this, right, when the constitution was drafted, is the one man, one vote principle. The idea is that each citizen ought to be represented by government equally. That is basically the idea. How is this supposed to come into play? Each constituency basically has to have approximately equal number of electors. Now I'm going to tell you how it has diluted over the years. I think Chin Hua has touched on it, but I'm going to show you how it's a little bit more difficult now to know exactly what is approximately equal considering the legal developments. Okay, approximately means that exactly equal numbers is not possible. And in fact, the Constitution has the word approximately equal, right? The exception that the Constitution allows has to do with rural areas. And I think Chin Hua did mention that, it seems that rural areas, the weightage of your votes would actually be more because, for example, basically the reason behind it is that if I draw the boundaries of a rural area too wide, the candidate that is standing for election has to do a lot more work than, for example, an urban area where the boundaries are actually smaller. So having taken that into account, that is why I think that provision was drafted that way, right? Okay, so that deals with the why. Now, just now I said that, right, why is it difficult now to know exactly what is approximately equal? Before the Constitution was drafted, there was this body called the Reid Commission. I'm not sure whether in history you all still remember or not. Where the Reid Commission actually suggested that the disparities between constituencies is supposed to be about 15%. So there was actually a cap to it. What later happened was, in the 1962 Act, Constitutional Amendment, they did not take into account what the Reid Commission said. Instead, they gave their own weightage, 2-1. So from 15%, it became 2-1, which is actually quite a huge difference. But at least there was a cap. So you won't have, 1 to 4.5 as we have today. However, now, today, we're actually faced with the definition of approximately equal. What does that mean? It's very difficult to determine, and having gone through litigation in and out of Malaysia, I can tell you that it's going to be difficult because it's actually a bit perceptive. And once you have such a vague definition like that, if you go into court, trying to justify why 4.5 is not approximately equal to 1 is going to be, on the face of it, it's obvious, but there might be other considerations to override it, which doesn't make it so straightforward. All right? So what can we do? Register your objections, please. I mentioned just now that the EC has very wide powers. Don't worry about it because as lawyers, we always think that you have the right to representation. Legal representation is a must. So it's probably something that we have to think about. After you register your objection, please don't just stop there. If you go for the local inquiry, ask the EC, what is your decision? I've gone for your inquiry and I am entitled to know. Please don't be surprised if the EC doesn't reply, but we have to do our part. We have to ask the EC for their decision because these decisions will form the basis of the court case, right? I mean, we can wait until they publish their recommendations again. It's a little bit more work, but at the same time, if we are empowered to do our part, I don't see why we shouldn't. Look out for the second gazette, the second notice. I have a feeling that the EC would have to revise the recommendations based on the objections that you have filed. Look out for the gazette. Find out what the EC has actually done to address your complaints. If the EC has not done anything to address your complaint, please approach someone here on the panel. I'm sure Maria will be very happy to, deal with this with you. Because again, like I said, unless there is a decision to be challenged, it is very difficult to go to court. All right. On that note, I end my talk, and I hope that it has been assistance for you. Thank you.